Hi, my name's David. I am a retail theft consultant, and let me explain to you a little bit about what that is. I am a current and loss prevention professional, which means, those are those people you see in stores that arrest shoplifters and prevent shrink, as they call it. But I also, as a retail theft consultant, work both sides. In other words, I will help retailers reduce their shrink level again, which is what they suffer due to loss, and it's not just theft that's loss. And I help those that have been accused of shoplifting, because not all of you are bad people. In fact, most of you are not. Most of you are just people who made bad choices. And sometimes there's things you can do to minimize the damage that your bad mistake on you. Why should you let one mistake ruin your life, right? Okay, and lots of times I get posed lots of questions. You'll see some of the other videos I have on here, or about civil demand and other issues. Today we're going to talk about being an accomplice to shoplifting, or accomplice to shoplifting, secondary, however the law or you want to word it. What frequently happens is somebody will come onto a forum site or come to me and say, hey, my friend stole something. I didn't take anything, but they arrested me too. I'm being charged. What can I do? What can I not do? And a lot of times people go to legal forums, of which I belong to many of them, and they ask the same question, and they get told information that is accurate, but it does have, let's say there's some wiggle room for this. Legally, okay, the way the law works and the way the law is written is you cannot be found guilty of anything they cannot prove. They have to prove your guilt. You do not have to prove your innocence. You have to prove your guilt. Okay, that being said, if you didn't steal anything and you didn't hand it to the person or in any other way aid in the theft, technically, according to the law, you are not guilty of theft because you did not participate or anything. However, that's not always true. Okay, again, the way the law tells you, so a lawyer, a police officer, and all these people that deal in the specifics of the law, and I'm not saying I don't, will tell you that, and that's absolutely 100% accurate. The problem is this. If you don't have money for a lawyer, and I'll get to that in a minute, if you don't have money for a lawyer, then it's going to be very hard to find somebody help you with this. And to add to that, the cost of an attorney to fight a shoplifting charge will exceed the cost of the fine. And there is no guarantee that you will win your case, which means you're still going to be out, let's say $1,500, $2,000, and still have to pay the $500, $600, $700, $800 fine, community service and whatnot, and have a criminal record. Okay, that's why quite often you'll hear people offer plea deals for diversion and whatnot, which we can talk about on another day. So again, yes, legally they have to prove your guilt. However, it's not as cut and dry as you think, and it would require you hiring a lawyer and basically fighting the charge, which is going to cost you more than the fine itself. So you have to decide what's more important to you and how you go about it. Okay, again, it's going to be very difficult to win the case, okay, especially dealing with a public defender or somebody else. Let me point something out. Yes, you have to prove your guilt, but if you're standing next to somebody who grabs something, puts it in their pocket, and walks out the door with it, you had knowledge. Did you do anything to stop it? Are you required to do anything to stop it? No, you're not, but you could say, hey, don't do that, and walk away. If you didn't do that, you're going to have a problem. Now, in some cases, the DA may look at the case and he may feel that the case isn't strong enough and he may drop the charges, or he or she. So I would advise you to wait to see what the DA does with the charges before you take any action. But again, it's not as easy as some people would imply, saying, okay, they have to prove your guilt. Yes, they have to prove your guilt. But if you're a jury member and you see two guys standing next to each other, one of them steals something and the other one's standing there, do you really believe he didn't have knowledge, that maybe he wasn't a lookout, or maybe he didn't say, hey, steal that? There's no way of knowing. It's his word versus the other person's word. So what do you do? That's exactly my point. So use common sense. Remember, It's not as cut and dry as they have to win or they have to prove their case. Yes, that's exactly what the law says, but in order for you to do that, you will literally have to fight the case. And fighting the case will cost you more than the fine. All right? So I'm not advising you to plead to something you didn't do. I'm not giving you legal advice at all. I am just giving you information that may prove helpful as you attempt to deal with the legal system if you've been caught shoplifting. Being an accomplice to shoplifting is not that hard to show a jury that you're guilty, okay? If you're present there, if you're looking around, any action, because the video, if they have any, and the witnesses are not going to be able to detail any conversation, but they will show the fact that you were standing there while the person took that. They will show the fact that maybe you're looking the other way, like you're looking for a lookout, okay? The jury can decide from there. Now, your attorney can certainly say, okay, the person was looking the other way. Maybe there was something there to look at. Maybe there was a loud noise or something. We don't know. Again, that's reasonable doubt. It's certainly plausible, but are you willing to risk your freedom, your money, and whatnot for that? So again, use caution. Think about things carefully. Talk to any attorney you have. Weigh the pros and cons of what's good, what's bad. Look at the money factor. If you don't have money, you may not have an option. But remember, it is not as cut and dry as they have to prove their case. Okay? If you watch the news at all, you'll see cases are won and lost with tons of evidence or no evidence all the time. So it's not that simple. Yes, the law says you must prove somebody's guilt, but it's not going to be that hard for the DA to show a jury enough to convince them that you actually stole something from this store or aided in the theft. Again, if you are present at the time of the theft, you are within an eye shot of it, you're standing next to them, or if you are acting as a lookout or in any other way that implies, again, I'm saying implies, that you had knowledge or participated in some shape or form in the theft, then a jury is going to buy that, and a jury is going to probably convict you, and then you're going to be stuck with this huge legal fee. You're going to be stuck with the full sentence of the shoplifting. If the shoplifting case carries a full sentence plus a criminal record, you're going to get all that. There are options out there that work like a guilty plea but do not result in a conviction on your record once you pass certain criteria. These are all things to discuss with an attorney before you make any decisions, before you pursue anything. But again, legally, yes, the DA must prove his case. He must prove you participated in some way, shape, or form, had knowledge, or in other ways participated in the theft. But unlike the presumption, it's not going to be that hard for the DA to show a jury that it is reasonable that you had knowledge. Again, if you're standing next to some person while they take something, put it in their pocket, chances are you had knowledge. Even if you didn't, and I know they need to prove your guilt, not the innocence. Trust me, it doesn't work that way. It should, but it does not. All right? The DA knows this. The DA will manipulate the jury to show just that. Say, look, he was standing right there. How could he not know? He was looking right at the person when he stole it. Or look, he's acting as a lookout. You can see he's clearly looking as a lookout while the other person is putting something in his pocket. Okay, again, use caution before you decide to do this. Remember, being an accomplice to a shoplifting is just the same as being the shoplifter himself, with the fines, penalties, community service, jail if necessary. All that still applies. So use caution. Talk to an attorney. Ask lots of questions. If you're unsure about some of the questions to ask, feel free to contact me. My email is retailtheftexpert@gmail.com. That is the word retail, the word theft, the word expert @gmail.com. No spaces, no underscores, retailtheftexpert@gmail.com. Email me anytime. I will email you back within 24 hours with your answer. You have a nice day, and I am David, and I am a retail theft consultant.